and Mr. Kalich. Come on up. Come on up and take a seat. Thank you for being here, first of all. Second thing, when we met last time, which I believe was a week ago, either a week or 2 weeks ago, I'm just going to be upfront with you, and that I appreciate that you've dressed for court. You, in my view, engaged in a lot of inappropriate behavior on the Zoom call, and I just want to say at the outset that that's not going to be acceptable here today. Do you understand that?
I understand that, Your Honor. May I apologize?
You may.
Decorum in your courtroom last time.
I appreciate that.
Completely out of line, and I apologize.
Thank you. Next, it'd be Mr. Weaver and Ms. Sims. Could you come on the Zoom call, please? There you are. I can see you now. Okay. So are you prepared to proceed here today, or given the late service, I can reset this for a week or two, probably two, and then come back and give you a chance to respond what's being alleged in their petition? Are you ready to go now, or do you want time to get ready for it?
No, I'm totally ready to go now. Honestly, the only thing I'm concerned about is payment, because they owe me money.
Okay, nothing, that's not in front of me right now. The only thing that's going to be in front of me right now is whether they get an order or not, one way or the other.
Well, I don't care about that. As long as, I mean, because I don't understand how I'm supposed to get my money from them and contact them. I sent them an invoice, and I actually, as it works out, the bank that I currently am banking with is going through a transition where it's Security State Bank transitioning into Giza Credit Union. So I call and I can't figure out whether they paid me or not. So that's all I really care about is getting paid.
Okay.
So, I don't care if I talk to them. I just want to know if they paid me or not.
Then we lost him again. What's that?
When was it served?
No, it's bad connection.
Your Honor.
Yes, I'm going to wait for him to come back. I don't want to talk to him without him being here, but now he's back. Okay, Ms. Sims, what would you like to say?
The papers were served to Mr. Kalich on Thursday.
Okay, and that's still not enough time, ma'am, but that's
okay.
Go ahead. Okay, ma'am, Mr. Kalich, I need you to be quiet here for just a second. Okay. So what's this about money being owed to Kim, or is that a disputed, or what exactly?
No, we have hired Dan on numerous occasions to do various projects, and the billing we received was recent. There was one that he included in his text that was inflated and outrageous, but it looks like he's sent to us both a reasonable billing for the work that he has done. A phenomenal job, by the way. And but something has happened where the things went sideways with what all these text messages that were coming in.
So again, is there an agreed amount you're going to pay him, or is that in dispute? And Mr. Kalich, I need you on screen there. Yeah, go ahead. So it sounds like you've had a business relationship with him for a while.
Yes.
So is that a disputed amount, or what exactly?
Part of it is part of it is disputed, yes.
Okay.
I'm trying to get back on. I don't know if I'm on camera.
You're on now. Yeah, no, you're on now. I wouldn't talk with the other. So, Mr. Kalich, I need you back on, please.
Oh, okay.
Okay. So there's not a temporary order being set in place. There's so folks can communicate with each other. You know, I'm not going to do this hearing with this glitchy technology because you keep losing, you're coming back, and you know,
I'm sorry.
On and off camera. Well, hang on, we're not just hear me out. You know, I get to make some decisions here, and here's what's going to happen here today. What's the next one?
Jeez.
2 weeks. We'll see you next Monday, first of all.
You can see.
Yeah, next one.
Oh.
Yeah. So Mr. Kalich, it kind of looks like I'm looking at a cat and some feet.
I know. I fucking gave up at this point. Like, I'm literally trying. I fucking gave up.
Here's, you're in court, and I always appreciate it when people act and speak as if they are in court. I'm not the biggest fan of Zoom because it kind of lends an air of informality, which should be a formal proceeding. And so
I'm trying, dude. I'm literally trying. I'm literally trying.
Hey, remember what I said about not interrupting people?
Okay.
Don't interrupt me either.
Okay.
And so we're going to reset this for 2 weeks. You need to be back here, there, and then I'm going to require
them to pay me.
What's that? No, then we're going to have a hearing on this anti-harassment petition. If they pay you, and that's entirely up to them. That's not in front of me. You need to start your own lawsuit if you think you're not getting paid. But you need to be here in person for the anti-harassment petition.
All right, fair enough.
All right. And then so again, then this will be your notice. You're not going to get any notice other than this. You need to log back in 2 weeks from today.
So how do I ask them to pay me the money?
Well, I kind of think you did, first of all. And secondly, I can't be given advice to one party or the other. You don't want me telling them how to present their case. My guess is, it's just between you folks. And so, they've said they've appreciated your work. They agree they owe you some money. Apparently there's a difference on how much, but I'm just not going to get in the middle of that. The only thing I'm here for is to whether or not an anti-harassment order should be entered.
Oh,
and
so
we're going to
make
make
your decision on the anti-harassment order.
What's that?
What's your decision?
I'm not giving one. I'm telling them we're going to do this in 2 weeks when I know everyone's here and I'm looking people face to face, not face to foot.
Well, dude, fucking make a decision. You know it already. Why? Because at this point, this is harassment to me.
Okay. I'm sorry you consider
they
that
are harassing me.
Mr. Kalich, you're going to sign. You're going to sign off. We're going to reconvene in 2 weeks. And if you don't appear in person, then an order will get entered in their behalf.
And
that's
I
going to
don't
conclude the hearing here for today. We'll see you in 2 weeks.
Care about is getting fucking paid. They owe me money. Fuck.
And then, can you get him off the call? Yeah. We'll see you in 2 weeks. And Mr. Kalich, come on up. And so let's talk about the order then. So you've heard what I've said before about what unlawful harassment is. I'm going to swear in Ms. Weaver, who I think was speaking last time, and then I'll hear from Ms. Weaver. There's other people there with her, but she's the only named petitioner. And then after that, I'll hear from you. And then, so Ms. Weaver, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And so if I remember right, and I encourage everyone to correct me if I'm wrong, he's done work for you in the past, and then is that kind of how this all started in terms of payment and all of that, or what exactly? How is it you need an order against Mr. Kalich?
Mr. Kalich, unprovoked, started sending hundreds of irrational and disturbing text messages to a thread that he created to me and to several of my family members on that thread.
And then what's this all about?
I'm not sure.
Well, from your perspective, you must have some idea. I mean, and I hear all kinds, I hear neighbors getting fights with each other. Domestic relations, which we saw earlier. And so I assume that this just didn't happen out of the blue. And so that he's not a stranger to you prior to all this.
No.
And so
And he
talk to me about that.
He had acted in good faith, and my understanding is that this is not the first occasion that he's targeted someone with these kinds of text messages. And I think the trigger possibly was alcohol and possibly some drug involvement. I'm not sure, but this is not normal behavior for what my experience was with Mr. Kalich.
Okay. And then how long have you known him?
Maybe 3 months.
And then did he do work for you at some point, or?
He had done some work for our local nonprofit, and also for my parents and my sister. And okay. I had him working on a rental of mine.
Okay. And then how did that go? Or was that
fantastic?
Okay. And then has all this stopped?
The work is stopped.
When the order was entered, it stopped? Okay.
What did did the text stop?
What, I'm sorry?
I don't understand. Did the work stop or did the text?
No. The harassment. We're here for a harassment petition. So
okay. So after about 16 hours of constant barrage of texting, I blocked.
I saw all them there, and I'm going to talk to him about them in a minute.
Okay. I blocked.
But go ahead. Continue on.
After about 16 hours, I blocked the text thread myself.
Okay. And then, let me hear from Mr. Kalich, and then I'll come back to you in a moment. Or actually, Mr. Weaver. Is that Mr. Weaver behind you?
It is.
Okay. And so, Mr. Weaver, I'll have you raise your right hand. He has two separate cases here with two orders. And do you swear and affirm the information testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And now, how is it that you need an order against? And Ms. Sims talked about the text. The texts are in the file, which I've read, and I'm going to talk to Mr. Kalich about it in a minute. What's your position on an order? Why do you need one?
Well, my main I became very concerned when the text started talking about raping and killing a 13-year-old daughter of one of our tenants, and that really was of concern to me because we had him working on rentals and going in and out of rentals and things, and it just didn't. It seemed like very not normal situation when he starts talking about us sending him in to a rental to work, which was not true. He was supposed to be replacing a faucet outside of the rental, and the tenant evidently invited him in to look at a plumbing problem she had. And that, as you can see by the transcript of the text, it was very concerning to me that he starts talking about raping and killing a 13-year-old girl. And that, I think, is not appropriate and alarming to me.
Let me hear from Mr. Kalich. And so, Mr. Kalich, could you raise your right hand? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. So I have them up to me. I kind of agree with Mr. Weaver there. These are some disturbing texts that anyone would be bothered to receive, I would think. So what's your response on their request for an order? And they said an order is appropriate, or you're not objecting, and then I can enter one, or do you think that no, we don't need an order? Or I just want your perspective on all of this.
First of all, I have no need to contact the Weavers anymore, because the only reason there's in the body of the text, if you've read them, you can see there's several reasons why I was reaching out to the Weavers. One of them was their alcoholic daughter.
Well, that's their business.
Correct, but I talked to the sheriff, and the sheriff said I should act on it, and I was trying to get them to respond so that they would say they're going to take accountability for Shanna going to the soccer game and driving her kids home, so I would not have to call the sheriff or on them, because the sheriff did recommend I call the sheriff on Shanna on Wednesday night. And those texts were prior to that, leading up to Wednesday night, when I would have had to call the sheriff. Also, I was upset because Diane, who is in the background there and could be sworn in if she wants to talk about it. Excuse me, not Diane, but Donna. I was upset because she did actually fire me in writing, saying that because of me only texting Donna personally, said that I was unsafe around the customers, which I never have been. Fired me in writing, and then sent me to go and take care of the rest of the items. And what Gene said is not true. That the only thing I did talk to him about was the faucet, because I needed to talk to him about what to do. But I was directed by Donna verbally, and she can testify to this, to go and finish the projects I was currently on. And I told Donna at that time, that morning, I said, Donna, if you did not trust me, you would not send me to your projects. And so I had permission from the renter. I had Donna's direct permission to go, she didn't say go to the house. She said do the rest of the items, which included going into the house. I had the keys to the house. And so if I had, and the daughter was sleeping, the 13-year-old daughter. So I knocked on the door and no response. So I had authorization from the customer and from Donna to go in with my key and take care of the items on. And if I had somehow got in, saw that daughter say naked or something, I would have been in a terrible legal situation. And I was trying to emphasize to the Weavers that they put themselves in a terrible legal situation, because of what Donna did by putting in writing I was unsafe around her customers, and verbally directs me to go into the house with the customer when I had permission from the customer, when there was a 13-year-old sleeping daughter. I don't need to go on that. You can get the idea. So I was incensed because of them putting me in that terrible legal situation. I was trying to tell them how stupid it was to let Donna put me in that, themselves in that terrible legal situation. And I was trying to emphasize to them that they should change the locks that night on the door which is the only thing to do, because I had given my key back to the customer, but they don't know that. They don't know that I hadn't made a copy, or anybody else for that matter. There's other people that had keys to that property. And so if they're going to fire me for being unsafe around the customer, they better follow up and change the locks. And I'd like you to ask them if they even changed the locks that night. And I guarantee you they didn't. All they did was they notified the customer, and the customer told them that I was a perfect contractor and had never done anything remotely questionable and did perfect work for her. And they did not change the locks that night because they don't have a carpenter to do it. Right. Simply. And did not take the right, should have hired a locksmith that night. So that I was trying to emphasize those things to them in a very brutal way.
Yeah, we can agree with that.
And the only remotely threatening thing is a hypothetical, which is if something had happened that night, they would have been responsible. They would have been at fault, which is true.
Well, it doesn't. So here's where I'm at. Where you folks? You live in Elma? You're from Elma?
I'm sorry, can I say one more thing?
Sure.
Regarding the order itself? So I have no need to talk to them, but the thing is, I honestly think that when they come to their senses, they're going to realize I was trying to act in their best interest. Okay. I did it in not a very gracious way, right? But I am actually a good carpenter, and I think I'm going to be working for them within a couple of weeks, because they're going to come to the senses and they need the work done and they know I can do the work for them, and they're already paying me.
And she,
Apparently paying me. And I'll tell you, one more thing.
okay, yeah.
This has actually destroyed me in business. It's literally put me out of business because all of my insurance, bond, everything came due at October 31st. And I was expecting this money, which would have taken care of it. But because of this whole restraining order that Donna filed in the first place, I couldn't contact even Gene and Diane about it, but I only did contact them because my truck broke. So now I've lost my bond, lost my insurance, lost my license. My truck is broken, so I can't work. And so, I mean, I'll hopefully get that taken care of because they said they are going to pay me. But I just think personally, I think I would like compensatory damages on my side because this feels like harassment for me trying to do them good in a very rude way, I guess.
Well,
And plus one more thing, they could have blocked me at any time, So it's like, do you not know how to block people?
well, they might not actually. And
Yeah.
I don't know whether they do
Somebody
or they
has
don't.
to in that family. I mean, I've texted 5 of them. Somebody has to be tech savvy. There's younger ones there. I know Donna could figure it out.
Okay. So, did you have anything else? Are you good?
I guess
Okay.
that's it,
I
yeah.
want to make sure that you, and then, so Ms., I mean, what is the financial situation right now? He says he's entitled to some additional compensation. Do you agree, disagree with that?
I paid him.
You've paid him?
Mhm.
Okay.
To be clear, she's paid me, apparently held out court fees or whatever, which, like I said, I think I'm entitled to everything and some compensation for this harassment is what it feels like.
Okay. So, Mr. Kalich, so I've reviewed I've listened to your testimony. I've listened to, Mr. Weaver and Ms. Sims, his testimony. And I guess I'm going to start by saying, I read the definition of harassment. Something does not need to be threatening, to be harassing. I reviewed, and there's tons of emails here, which are, hang on just a minute.
Okay.
And so, here that, and again, that are very, they're just relentless,
May I
and that they
address
come
that,
through,
the
hang on,
definition?
let me finish,
Okay,
please.
sorry.
Starting at 7:13 p.m., 7:14, 3 at 7:14, 7:15, 7:19, 7:20, 7:21, 7:22, 7:23, 7:30, 7:31, 7:32, 7:30. I mean, just relentless. And to say, well, they should have blocked me. That's, you can't, for lack of a better turn of phrase. I mean, this is your activity. You're kind of blaming, they should have stopped me. And so, I do find that I look through the harassments, which I'm not going to read them, but they're quite insulting and demeaning. And, we can argue whether or not they're threatening to them or saying some things are disturbing. But, and again, on the 14th, it starts at 12:10 a.m. and just keeps going. And at one point you call them dumbasses, for lack of a better term. They're saying F you to Shanna, F you, Diane. And then, all kinds of F words all over the place. And it's not a defense to something of that sort to say, well, you should have stopped me from doing that. And so I am going to find that those texts are harassing. And then basically, if you don't have a relationship with them now, and you live in a different county from where they live, I think, it should just be easy just to, they're just not a part of your life right now, and you're just not to contact them. And if, as you said, that I'm not sure I agree with you based on, perhaps I'm incorrectly reading the room. I'm not sure that they would be enthusiastic about hiring you. I don't know that, but if they do want to, they can ask to rescind this no contact order and go back to ground zero, because apparently they did like the work you did, but no one should have to put up with a string of texts like that. I don't think, but go ahead. Now you wanted to say something. I'll let you do that now.
The only thing is you're misunderstanding my argument. So first of all, I'm
going to stop you, but I'll let you continue. But I'm going to say, I don't misunderstand it. I do understand it. I'm just not agreeing with it, but go ahead.
As you put my argument, you're saying that my defense is simply that they could have blocked me.
No, that's not. You're completely, you said that. And I don't think that's true, but I think your other defense is that I thought that you were trying to help them. And,
Correct.
but I think that that's the tenor of these texts is not helpful.
So
I mean, yes, you did say that, I did address that, but that's not the whole reason why I'm doing this, but go ahead.
because what I was trying to do is achieve a good purpose, which is also in the statute,
Mhm.
and several good purposes. I was trying to get them to change the locks that night. I was trying to get them to address Shanna's alcoholism that night and have promised me that they would do that so I didn't have to call the sheriff on them. And I had a deadline by Wednesday when I don't think she actually did show up for soccer practice. Now I think about it, she was probably out of town. However, I thought at the time she was going to. So all of these were good purposes. They had a timeline where I wanted some sort of response so that I could quit harassing them, as they say, and get their, some sort of response. And the thing about, I did accomplish, I also think I was trying to bring it to their attention how silly they were in their hiring practices for carpenters, because they just happened to get a good one, but they didn't vet me at all, including a state patrol report or anything. And so I was trying to get them to rethink about their whole hiring practice. If they did hire another carpenter, and their communication process about renters and putting renters at risk when nobody knows what's going on. And I accomplished all those ends through those texts because I guarantee they changed their behavior already about that. So I do think I accomplished a good end with those texts, albeit in a brutal way.
Okay.
So I don't need to talk to the Weavers, but I just think it's frivolous and it's harassment for them to bring it to me. And I do think you should compensate me for this lack of payment through this time, because it's cost me. It's probably $5,000 that it's going to set me back from this whole, because Donna couldn't take criticism in the first place and then blew the whole thing up. I think it's just crazy. And if you do read, I mean, that statute definitely says accomplishing a good end. And I think I was verified by the sheriff. I was trying to accomplish a good end. Even in just limit it to the drinking part and driving drunk with their kids, which is a practice that I observed and nobody else knew about. Also, I talked to Gene and Donna about Shanna's drinking, and they both responded, "Oh yeah, we've known about that. We've known we should do something about that," but they hadn't. And so that's the other reason I was pissed at them that night. Sorry.
Okay. So again, I just go.
Plus, the other thing is my pattern of behavior. The only time since I've texted them, since Donna's order, even any of them was about money. And I did text them one more after that court hearing, and I unlashed at you, and I apologize for it. But I did go to them, and I think I have them. They are blocked now, but it was just about money.
Okay.
And it's just like, pay me my money. So, and then they have paid me my money, but like I said, I don't really care to talk to them. I just think this whole thing is silly, and I think I am the one that should be compensated.
Okay. Well, give me just a second here.
Your Honor.
Yes, Mr. Weaver, or maybe no, you're not. Yes, Mr. Weaver.
Yeah. I'd like to address, if I could, we received a text message that that an invoice by text was a legal document, and that we owed him $10,000, and that was the whole extent of the invoicing at that point. Is a text that we just owed him $10,000, period, for the, as I recall, some reference to the pain and suffering we had put him through. But, and also that we owed him $200 that he had loaned to our granddaughter, which I don't see where we became responsible for money that he apparently freely loaned to our granddaughter. And so the delay in payment has been because I have been trying to figure out exactly what he did for the, what the invoice that for a detailed invoice of what he did and where and how much. And we've been trying to sort out what we actually did owe him, you know, and it's considerably less than $10,000 in my opinion.
So I can't make any decisions on who owes who
Right.
what. You know, that's not in front of me. And the only thing in front of me is whether or not an order should be entered. And you wanted to say, I see your hand
One
went
more
up
thing,
again.
please. On that note, as a case in point, the whole order precludes communication. We're currently communicating via my brother, who is also customer. The Weavers are his customer in another context, but which would also violate the order. Like I couldn't even communicate to the Weavers about money through my brother, according to the order. As I understand it. So I mean, the whole thing is silly.
Okay, so-
I don't need to talk to the Weavers except about money. And
Okay, so hang on just a second.
And that's all I need
So
to say.
did his brother works for you? This is news to me. I didn't realize this. Has he done work for you or what exactly?
Are you asking? I've known.
I'm asking anybody who knows.
Okay, I've known Dan's brother Ryan for a number of years, and he does home inspections for me.
And
Okay.
we didn't do a home inspection on the property that Dan was working on.
And can accept communication from, what's your brother's name?
Ryan.
From Daniel through Ryan. So I can put a provision in here from order that third party, just let me finish, please.
Sorry.
Third party contact allowed, you know, where, you know, he's not allowed to contact you directly, but he can talk to Ryan, Ryan can talk to you and then work out the money that way. Do you have any objection to that?
No objection.
No objection.
So we can do that. So again, you know, and I appreciate while your effort, I understand what your effort saying is. I'm just saying that the manner of these texts go beyond that. And again, I could give all kinds of examples in here where you're incredibly insulting to them and very rude, and it just goes on, and it is continuity.
Can I ask?
And so, hang on, just a minute. Remember what I said about interrupting? I'll give you a chance to respond here in a minute.
I appreciate
And you said, "F you, Weaver, you effing arrogant dumbasses. F you, effing small town royalty, effing bitches." And that's not an effort to help, really. I don't
think
think.
it is. I
Well, I
really
don't-
was
I
trying
don't-
to bring it to their attention
Okay.
how arrogant they
All right.
were, and I think
So
that
hang
if
on,
I had used,
just
okay, I apologize.
just a second. I've made my decision. I'm not going
All
to
right,
argue
that's
that.
fair.
But you
That's
wanted
fair.
you wanted to say something.
No, if you made a decision, then it doesn't
Okay.
matter.
And so, but I am going to put in here, is your brother's last name
Kalish, correct.
Kalich also?
Can I ask you?
Give me a minute. Let me get this right. Then you can ask me. Is that Ryan, just Ryan?
Correct.
Kalich, K-N. Okay, you had a question. Wait, did you have a question? You said, I did a question. I wanted to finish what I was doing here.
In the order, they asked for the compensation for attorneys for,
I'm not, there's no compensation. I'm
Okay.
not awarding that.
so they are not awarded any
And
compensation.
no
either
fees.
way.
Nope. I'm not, and so, and if you have a financial situation, so the parameters of the order are, you're not to contact them directly, no, engage in stalking behavior, don't cause them any harm, don't come within 1,000 feet of their residence, place of employment, or themselves. I did write in there on the contact provision, I said, third-party contact from Ryan Kalich is allowed. So if he has this incident, he can tell Ryan, Ryan can tell you, that's not a violation of the order. Do you understand that? But if you say something incredibly insulting to Ryan and he passes it on, then we might be back here. Do you understand that?
Fair.
The purpose of that is so. That'll conclude the order. We're going to give you copies of the order right now. And then, do they get emailed a copy?
I can email them.
A copy of the orders will get emailed to you folks as well.
Give me a minute.
Thank you.
Thank you.
Wait, when we get the copies, you can get copies of it and then you guys are free to go.
Paul J. Schwab versus Irina St. John, and Irina St. John versus Paul J. Schwab, 2501729. All right. Names, please.
Good morning, Your Honor. Paul, improper.
Ma'am, your name?
Good morning, Irina St. John in Frankfurt.
Okay. All right, this is over attorney fees. You filed a counterclaim. He,
Your Honor, if I may address the court, which may expedite matters. The principal case is breach of contract, Paul Schwab versus Irina St. John. The contract is bidded in answer paragraph 3. In my complaint, I cited the contract. She admits it, so there's no question we have a contract. The only issue in my case in chief is the balance that is unpaid. I pled the pleadings, I pled the fees, and she said something to the effect of, well, they're unreasonable. So we'll litigate that. Her complaint is her counter complaint, as the court may be aware, is alleging everything that I could possibly do evil, including malpractice, legal malpractice. And she's saying, I don't owe my money back. Well, in our last pretrial conference, Your Honor cautioned her, Ms. St. John, you need an expert witness. And the witness filing deadline was November the 1st. She named her friend, Julia Belova, 30 years ago. That is stricken. She does not have a witness to support her counter complaint. And I have filed a motion waiting until the filing date is over with, giving her plenty of time to file before the date of trial. I have a motion pending to dismiss the counter complaint. She cannot prevail. She does not have an expert witness. She cannot testify as to the standard of care. She cannot testify as to reasonableness. Now, she just the other day filed another answer, and there's not one case cited. So she does not have an expert witness. She cannot prevail on a medical malpractice case.
legal malpractice.
Legal malpractice.
How are you going to prevail on that, ma'am?
Well, first of all, I would like to say that plaintiff filed his complaint on April 23rd. I filed my counter complaint on June 2nd. Plaintiff have plenty of time to file this motion. I'm following your pre-trial order, and it says, which was on July 29, 25, that no motion will be heard on the day of the trial. All motion needs to be filed no later than 20 days prior to the trial date, which plaintiff again goes against your order. Also, plaintiff cite his motion, he cite Michigan Rule MCL 600.2169, and this rule states that qualification of expert witness in action alleging medical malpractice. It doesn't say anything about attorney malpractice. So plaintiff.
You can't testify what the standard of care is because you're not an expert.
Yes.
I can't testify as to what the standard of care is for a orthopedic surgeon, a cardiologist. I know nothing about that. I'm not qualified. Neither are you to testify as to what the standard of care is for what he might have done wrong and that would subject him to a malpractice claim. That's your counter complaint.
My counter complaint about monetary damage.
I know it is, but how do you have monetary damage unless you have an expert here to say he cost her money because he didn't do something he should have done, because that's the standard of care. That's what a reasonably prudent lawyer would have done under the circumstances that was handling a divorce case. He would have had an appraisal done, or he would have had bank account records subpoenaed, or he would have asked interrogatories concerning the finances. Ma'am,
And I do have this in my brief, overcharging that he overcharged me. He was charging me prior to signing the contract, which is and it's a big amount. It's all in my brief. That before we signed contract, he started to charge me for some preliminary work. I still was shopping around for the attorney represent me in my divorce case. I have multiple emails that I
okay, but
provided
that
he said that if you decide to hire me on December 13th as your attorney, if you decide to proceed with me. So I didn't hire him as attorney, and he started to charge me thousands of dollars before I even signed a contract. Then he charged me for presence in my house for appraisal service.
Look, I'm gonna cut this short. I'm not gonna strike her counterclaim now, but she's not going to be able to testify as to what the standard of care is with respect to a lawyer in handling of a divorce matter for you or on your behalf. I need to get off this bench for a few minutes, and my staff's entitled to a little break. I will come back in 10 minutes. We'll start the trial at 22, and I will ask you then to give your opening statements, okay? Thank you very much. Okay. We're back on record, Schwab versus St. John, and of course I have a counterclaim 2501729. Your name?
Paul Schwab, improper.
Irina St. John in Brooklyn.
Okay. Any preliminary matters anybody needs to bring up? Besides what you already did?
No other matters, Sean.
Ma'am, anything you need to bring up? Call you, do you want to give an opening?
Improper.
Okay, sure. You can have a seat, ma'am, and then you'll have the opportunity to give an opening, okay?
Your Honor, as indicated, this is a breach of contract lawsuit. There's no question as to the contract, its existence, its terms have been admitted. Answer number 3 to the complaint admits the contract. Sole issue in the breach of contract is the attorney fees, the reasonableness, the work that was done, and there will be an exhibit marked a narrative detailed billing. It consists of about 6 pages of computerized entries at times and confirmations, very detailed. Testimony will also show in the case that these documents were given to the defendant, Miss St. John. There was never a complaint of overbilling, nothing. It'll show that Miss St. John changed attorneys and refused to pay the balance on the final statement. That led to the lawsuit. I anticipate that there will be some attempt to testify as to the counter complaint. And again, if history is any indication, that could be very lengthy as to the plaintiff. I anticipate a motion for directed verdict at the conclusion of the plaintiff proofs. And the court is aware there will be no expert testimony and it just cannot prevail. At the conclusion of the court hearing, I will ask for a judgment of the amount of attorney fees and some of the costs and some of the interest. And that will conclude this matter. I anticipate my case may take 10 minutes.
Thank you.
Thank you, Your Honor.
Ma'am?
First of all, I would like to thank you, the court, for opportunity to represent myself in court. I believe in American transparency and justice of American court. Can I disclose the situation when Mr. Schwab called me during your proceeding and tried to negotiate with me? Can I disclose this information?
Settlement negotiations are really not admissible in the trial.
Yeah, so Mr. Schwab called me and he tried to negotiate with me. Can I disclose what he offered to me?
No, because settlement discussions are not part of the process, that they're not admissible.
Okay,
Okay?
I agree with this. Mr. Schwab just mentioned that he filed this motion to dismiss my counter complaint, and he stated that he 99% sure that you will dismiss this. I don't know why Mr. Schwab is so confident about this. We'll see. I hired Mr. Schwab on December 13, 2024, as an attorney to represent me in my divorce case with my husband, Michael Azell. I signed the contract at that day, at the end of our first meeting. Mr. Schwab overbilled me without my consent for $2,550, charging retroactive charges before I signed my contract. This is included in my counter complaint. He charged me for the days for the December 7th, 9th, 10th, 12th, and 13th before I signed my contract with him. I have exhibits of 2 letters from Mr. Schwab in which he's saying that if you decide to hire me on December 13th, we will sign a contract and I will explain you my attorney fees. According to the Michigan Court's Civil Proceeding Bench book about attorney fees, 8.6, it says that attorney-client relationship must be established by contract before an attorney is entitled to payment for service rendered. And also in the Michigan Rules of Professional Conduct, it says that a lawyer shall not make an agreement for charge or collect an unreasonable fee or unreasonable amount of expenses. I hired Mr. Schwab, experienced attorney, 55 plus years of practice. And I know that it's very unusual for client to file anything against attorney. And I have exhibit 2, which represent total 13 cases in the last 18 years that Mr. Schwab was suing his clients, and I'm one of them.
Okay, but why is that relevant?
It's relevant because I became a victim of his scheme when he intentionally overcharges his clients, then brings him to the court because he feels very comfortable in a court versus me, just a regular person. I'm a registered nurse. And then he overburdens the court with multiple motions. Like in my case, it's a motion, multiple 4 motions for frivolous pleadings. Whatever I did, following your court rule, I had the right to present a witness. I filed my witness list. I had the right to submit my affirmative defenses. I submit them. So everything was a frivolous pleadings. And he was asking for sanctions multiple times. So that's why this is his pattern. Overbills a client, file frivolous lawsuits for unpaid fees, request multiple sanctions, and enrich himself. So he's suing me for amount of $1,600, and everybody would say, you crazy, go to court and file counter complaint against your attorney, just pay this. And I made my informed decision that I'm not going to pay this because I firmly believe that it was grossly overcharged and overbilled. I presented in my counter complaint section by section that he overbilled me without consent for $2,550. He coerced me for appraisal service of his choice, which was deficient and not admitted, and mediation by a mediator. Versus 1,000, he charged me $6,495, which I paid $3,570 for appraisal service, and all the rest, it was his middleman work and presence at my house for 3.4 hours as, I don't know, bodyguard or who. I don't know how it can be justifiable, charge someone attorney fees for being present at appraisal service. It's two independent men, they're working independently, they're doing their job, so I cannot justify this. Also, a financial discovery, 4,200, which what Mr. Schwab did, he filed interrogatories, which was grossly inefficient, contained only 13 questions, was very repetitive, so it was actually 4 questions. And they allowed my husband to answer very vague and did not provide any substantial information. And also his unethical behavior, a failure to follow own contract, which according to his contract, I had a due date to pay my balance 14 days. He filed a complaint with this honorable court 7 days before the due date. That's all in a contract. Also, he disclosed my personal information with my present attorney, Michigan law. He sent them his statements from his answer to my complaint to Michigan Grievance Attorney Commission. Mr. Schwab knows that I represented myself improper here, and with that case, I don't know why he sent the whole package to my attorney. So he was very surprised too. And also he disclosed some confidential information with my husband when my husband called him. He called me a psychopath. He disclosed some information about my Ukrainian family. And who knows what else he disclosed with him. That could damage my case also. So I'm asking the Honorable Court and you would be honored to help me, with this case, because I think it's very grossly overbilled and Mr. Schwab did a lot of mistakes. That's why I asked you to reward me $10,000 that I paid for case that just started in Mr. Schwab's case and dismiss his complaint with prejudice.
Thank you. Call your first witness.
Your Honor, I'll call on Rita St. John.
Okay. Ma'am, you can come right up to the witness chair here, okay?
You can walk right in. Grab that ramp right to show.
Yeah, right up here. Okay. Raise your right hand. You solemnly swear or affirm the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, I swear, I do.
Okay. Have a seat, please. You may proceed, Mr. Schwab.
Could you state your name for the record, please?
My name is Sabrina St. John.
And where do you live?
I live in Grossville, Michigan.
And who do you live with?
I live with my husband, Michael Lizelle, and my daughter, Elizabeth St. John.
Is there a divorce complaint pending with your husband, presently?
At the present moment, my divorce is, we filed the motion for dismissed of the divorce on November 5th.
So he dropped the lawsuit against you. The divorce is over with, right? You're
Yes, we
married.
decided to preserve the family.
Do you remember contacting me December the 5th, 2024? Your first call to me?
It's hard to recall, but I recall it, yes.
Yes. You were referred by a mutual friend, weren't you?
We don't have any mutual friends.
Olga? Olga,
That's your former client. She was not my friend, I never met her.
she lives in the same apartment complex as your mother and your brother, right?
I never met her in my life.
We spoke that day, didn't we?
We had a conversation on the phone, yes.
You told me that your husband told you he has filed for divorce.
I said that I think my husband filed for divorce.
You were upset, weren't you?
Or wouldn't you be upset?
Okay, just answer his question. Were you upset?
Yes, I was upset. I was shocked.
I offered, you didn't have a copy of the complaint, correct?
Of course, because he didn't file at that moment.
And I offered to go down to the Wayne County Court, see if there's a divorce complaint filed, correct?
On December 5th, no, I don't recall that.
Did I go down to see if there was a divorce?
I don't know where if you did or not.
That worked. First telephone call, the visit to the court, the telephone call for you to tell you there is no complaint filed, to talk to you more about your daughter. I didn't charge you for any of that, did I?
I don't know, does it states a chart in your, does it says anything?
I'm gonna show you what's been marked as Exhibit 8. John, to introduce this is offered as the billing statements for my work representing, there are two statements, one dated February the 28th, the second April the 16th.
Of 25,
Those,
of 25, correct?
April, yeah, 25,
And is that marked plaintiff's one,
Exhibit A.
8?
Okay,
Exhibit A is an apple.
Good enough. You may approach the witness.
Look at the first four entries on that statement. Dated, the entries are dated December the 5th, December the 6th, December the 7th. Any charges for that?
according to your contract, no, it says no charge.
You continued to talk to me, didn't you, after that? You called me. I called you.
I talked to few attorneys, yes, I was searching for a
No,
good
that's
attorney to
you
represent.
To me,
Yes, I still talk to you.
right, and you
Yes.
talked to other attorneys,
Yes, and I talked to another attorney.
right, and you hired me, didn't you?
I hired you on December 13, 2024, when we signed the contract at the end of our meeting. This is when I made my decision. Yes,
You received a copy of this billing dated February the 28th. You received it by email on February the 28th, didn't you?
I received this, I signed the contract on
No, no,
December
question.
13,
Listen to the
24,
question.
and I received your first invoice on February 28.
That's what he asked.
Yes, 25.
Yeah.
Against your promise, send me a monthly billing every month. Right?
You,
So 3 months later, yes, I received your first invoice, that's correct.
did you object to this billing when you received it?
Can I clarify this?
Yeah.
So when I received this first invoice, we had a very hot, how many hours conversation regarding stagnated discovery? It should be in his bill. 90 minutes, so it's the last page. It will be, oh no, it's 2 here, so it will be end of the first invoice. Page 3, it will be hour and 20 minutes phone conversation on 2/28/25. When I was the first complaining about stagnation of my discovery. So at that point, it was almost 3 months and nothing was done. The answer to my complaint was never filed. It was filed 123 days after the due date. It actually was filed on April 15.
What?
Discovery was not
What was filed on April?
the answer to
Complaint.
complaint, to my husband's complaint. So it was 123 days overdue.
All right, but that's kind of customary in the practice for lawyers to get extensions. So I'm just telling you, you didn't go into default at all, right?
It could go to the.
Yeah, but you didn't go into default.
It didn't.
Okay.
Lucky for me. So the discovery was in stagnation, and I was asking Mr. Schwab what we can do. So my husband submitted financial statement, which was lacking all the information, bank accounts, his income, and I asked Mr. Schwab to proceed and force opposing side to provide information, all missing information. Mr. Schwab didn't file a motion to compel. Mr. Schwab didn't file anything with the court to expedite the discovery, to proceed with discovery. I asked him, can we subpoena bank records? Can we do something? He started to impose for me appraisal service. He shifted away from discovery, and that's where I was upset. And this is when I said that.
Okay, so here's what you're doing right now. Just let's slow down. You're engaging in a narrative right now. You'll have a chance to do that later when
Okay.
on cross, so to speak. You're going to basically cross yourself. You're going to tell me your side of the story.
Okay.
But right now, I just like you to answer his questions.
Okay.
He sent you this invoice on February 28 of 25, correct?
Yes,
And that's the date of the invoice, correct?
that's when Mr. Schwab sent me his first invoice.
Right, on February 28th of 25, correct?
February 28th.
Okay. And I think his last question was, you didn't object to that invoice at the time, did you? Or did you? I don't know if you did or not.
I was so upset that I did not object to this at that time. That's correct.
Okay. Ask your next question.
And you did not discharge me, did you? You didn't call me up and say, you sent me this billing? Stop work. You didn't do that, did you?
It was my biggest mistake. I didn't. I did not.
So you allowed me to continue working for him, didn't you?
Yes, I did allow it.
Right. Now, do you have any idea of the conversations I was having with your husband's attorney?
I believe that attorney's conversations are not subject to discussions with the clients, right?
Discussed it with me, didn't I? Told you I was talking to his attorney, didn't I?
Yes, you're supposed to talk to attorney. Yes, you did.
And I did. And you are upset by the information that your husband is giving you, correct?
I was upset of lack of the progress in my divorce case.
Right. Now we're into 2 months of your divorce, right? Now we decided, okay, let's do discovery. And I explained discovery to you, didn't I?
At some point you explained the
I gave you
discovery.
the court rule, didn't I?
Can you reference the court rule, please, which you're referring?
The court rule that says I can send him questions, but it can only be a certain number. And you wanted a lot of questions, didn't you?
I wanted as many questions to provide the information that I was needed, his bank account.
That's correct. And we sent those, didn't we?
You sent 13 questions that avoided information about his bank accounts. It was 13 questions primarily about his houses,
I sent you a copy of those questions ahead of time, didn't I?
premarital properties.
I sent those
Yes,
questions.
you
to
did
you,
send.
And you approved them, didn't you?
And you sent them to me and you said, I have to file them with the court as soon as I can. You didn't give me any chance to look, to think about this. So in 2 days, I called you and I said, I don't like the questions. They're very limited and inefficient. And this is when we got in a first fight.
Miss St. John, this was a divorce without children, correct?
Yes.
And I told you that this judge could insist that this entire case be done in 60 days, correct?
Don't recall this information.
She may get a trial date, correct?
We didn't have a trial date.
I know, but we could have got, what could we?
So why didn't?
The judge didn't set it, but he had the right to do it. I told you that we couldn't delay discovery, correct?
No, you said we need to do appraisals for premarital properties
They've got the appraisals.
and we will send interrogatories.
Okay. You were aware that we're under a very short deadline, 60 days, maybe a little longer, but we could have had a trial date, correct?
Without financial discovery, I don't think we could have a trial date. It would be very unfair to me.
You're not an attorney, are you?
Yes, I had an attorney.
You don't practice in the Wayne County Family Court, do you?
No, I'm a registered nurse at Hermanos Cancer Center.
Okay. We sent out the interrogatories, correct?
You sent interrogatories.
Yes.
You
Yes.
prepared them and you sent them.
And they were limited in number by the court rule.
Till 20 and you sent 13.
Yeah, but there were subsections, correct?
How many subsections was there?
I'm just asking you, were there subsections?
I don't know. You prepared them. You should know.
Okay. All right. So they were fine. Your attorney discharged his attorney, didn't he?
Wait a minute, I think you misspoke. You mean her estranged husband? You said your attorney discharged his attorney.
Yes, I'm sorry. Your husband, Michael Lozelle, fired his attorney, didn't he?
He did.
Yes, fired a new attorney.
He did.
Correct. And we were waiting for the substitution of attorneys, weren't we?
How long we was waiting for?
We were waiting, right?
How long we was waiting for? 7 days?
Okay, but you just have to answer his question, okay? Were you waiting for the substitution of attorneys? Did you have that discussion with counsel?
It was a substitution of attorney very shortly. I don't know what we was waiting. He fired attorney in 1 day and he hired attorney in the same day. So it was very fast. I didn't even notice that.
Miss St. John, you were in a relationship with your partner, Michael Lozelle, for numerous years, right? Well, since like 2009? When did you start living with him?
2014.
2014. And when did you marry?
2020.
So you were living with him for 6 years, correct?
Yes.
And your husband had what, 6 or 8 rental homes in Woodhaven, Trenton, Southgate, correct?
He has a few rentals in Southgate and one.
Those were in his name alone, weren't they?
Yes.
Not your name, you were on. The only thing that you were on was the marital home in Rosie. That's your name. You co-own the marital home.
Yes, you know that.
Yes.
I know, but he's asking you questions, now don't be so combative now, okay? Go ahead.
Yeah, I explained to you marital property and non-marital property, didn't I?
Yes, you explained this to me.
And I explained to you, much to your disdain or your concern, that in most divorces, when non-marital property, when your husband's separate property is kept separate, it's not subject to a settlement in the divorce. Remember? I explained that to you, didn't I?
Okay, you did.
Yes. And you were upset by that, weren't you?
I don't recall myself upset about this. I was upset about the divorce, not about separate
Oh,
property.
you weren't concerned about money? You wanted the best settlement possible, didn't you?
You offered me the best settlement possible.
You sure did. Okay, I explained to you a theory that we could pursue would be business law, partnership, and we could go after the appreciation. Not the value of the house, but how much they appreciated during your relationship, correct?
Correct.
Right. And we hired an appraiser, didn't we?
Yes, you stated that I can get appreciation from 2014 to 2020, and you suggested to hire an appraisal.
Yes, to establish how much the house is appreciated from 2014 to the date of filing. And we hired a licensed appraiser. An appraiser that is licensed by the state of Michigan.
You suggested your appraisal that the only will be reliable in a court.
No, I recommended an appraiser that I trust.
It's called a reference.
And he came to your house in Roselle, and he personally went to the 5 houses, correct?
Yes, he did his job.
And was your husband happy about that appraisal?
He allowed them to do, he agreed to appraisals.
Was he pleasant?
He agreed to appraisals. I cannot judge my husband's attitude towards that. He agreed, he went with them, he opened the doors for each house.
Did he allow you to go with us?
No, but I was not necessary to be there in his opinion.
Did you have any guarantee from your husband that he will allow that appraiser into these rental homes?
There is always a possibility that my husband will change his mind.
Right. And I explained that to you, didn't I?
That my husband will change his mind.
Yes.
I don't remember you explaining me this, but okay.
I appeared at your house at Roselle. The appraiser was there. You were standing outside the front door, and your husband was standing outside the front door. Remember that
It
morning?
was inside our house, not outside the front.
When I appeared.
It was allowed by me in my house, and he was inside the house, so it's incorrect.
Did you have any objection to me being there that morning? Did you say, go home, Paul?
I had objection prior to you to come into my house. But you came anyway. Because you love the Gruzil and you wanted the Gruzil.
And I went to the 6 rental homes with your husband and the appraiser, correct?
I don't know what you did after you leave the house. I didn't talk with you.
Then you discharged me. Said, stop work.
I discharged you on April 16, 2025.
I need that. Send me an email at 10 o'clock at night or something. Stop work.
No, not 10 o'clock after our conversation.
You sent me an email. Stop work.
Zach,
And did I respect your instruction? Did I stop work?
you ignored my email. I have to send you a second email and you responded to my second email.
And I responded by copying my entire file, correct?
You responded to me, you said, I received your email, I will stop working for you. But it was answered on my second email.
And I
Not my
did.
first
I
email.
copied my entire file, correct?
You didn't give me anything.
I sent it to your attorney, didn't I? Lisa Efros.
Lisa Efros, not my attorney. Lisa Efros is my husband's
I'm
attorney.
sorry, your new attorney.
Who was your new attorney, ma'am?
Michigan law, Derek Jacks.
Derek Jacks?
Yes. You sent the whole file to my address in Grosville, and on the top of that file was your complaint for this court.
Yes, April the 17th.
You didn't give it to me personally. You didn't send this to my attorney. You sent this to me by mail.
You haven't paid the balance of the fees on that final statement, have you?
That additional fee that you imposed, no, I did not.
And I've asked you to pay it, haven't you? Haven't I?
You asked through the complaint with this honorable court. And today we're here on a
And
trial.
I served you with it, correct?
You showed me with a complaint, yes.
So you know that I've asked you to pay the money.
And I answered to your complaint and I filed counter complaint for monetary damage.
I have no further questions on this, Sharon.
Okay, now you can tell me whatever you'd like to say as long as it's relevant.
I have my little paper.
I'm sorry, what did you ask?
Can I have my paper?
Well, you can't just read off of a piece.
No, I will not read.
Okay, what do you need the paper for then?
Well, Mr. Schwab has his papers and he was, and I
He
have,
wasn't testifying. What, you,
May I ask for clarification?
Sure.
I had just expected to give a few statements of sort of self-testimony and then I was gonna rest. Then I would assume that if Miss St. John has a case, she will testify.
yeah, you want to do it that way? I don't care. You were called. If you had a lawyer, your lawyer could ask you questions right now. Since your lawyer can't ask you questions, you can tell me whatever you'd like to say with respect to anything that's any way remotely related to what he's asked you. If you want, and I could care less which way we do it, he can testify now, and then you can come back up and tell me your story. Do you want to do it that way, or do you want to do it this way?
I want to ask Mr. Schwab a few questions.
Well, so how about so are you good with him testifying, and then you cross-examining him?
Whatever will be convenient.
Well, I want you to, I want you to decide. If you want to tell me your side now, you can, and then he can testify and you can examine him, or
My story and then I ask him a few questions, right? That's what you're saying me? No,
either way, you can either ask him questions after he testifies and then come back up and tell me your story, or you can tell me your story now and then ask him questions after he testifies, whatever you'd like.
I will tell my story.
If I may make a suggestion.
Sure.
If I testify now and rest, then Miss St. John can call me as a witness in her counter complaint, and she can testify it. So it's really two separate lawsuits.
Right.
But this way, she will testify, her attorney, if she had an attorney, would have asked her questions of all of that. So I think it would be, for the sake of the record,
And expediting it.
allow me to just testify and rest, and then she could call.
It's fine with me, whatever you guys want to do. Either way, you're going to get to tell me your story and you're going to get the question in.
Have my answer to what Mr. Schwab just was asking me. Can I do that? And then I.
Yes,
Yes.
she can do that. You can do that. So I'm going to let her testify, and then she'll sit down. You can call yourself. She can examine you, and we'll go from there.
As
Okay.
long as she understands that she can only comment or explain what I cover with her.
Well, I mean,
Okay.
she's got some leeway. This is cross. I mean, go ahead, ma'am. Tell me what you.
Let's make it simple. So I hired Mr. Schwab on December 13, 2024. The conversations on the phone that we had prior, I had multiple conversations with different attorney because I was never filed for divorce in America. I didn't know what is a proceeding, so I wanted to know how everything goes. So I was talking to few attorneys on a phone along with Mr. Schwab. And I was weighing my options. Some attorneys will be aggressive, some will tell you, oh, here is my strategies. somebody will, have a jokes with you, and you thinking and you looking. So prior to December 13, I was talking to few attorneys and looking for the best option for me. Mr. Schwab never told me that he will charge me for any of this conversation, not just for the first one, for any of them. He didn't disclose his attorney fee. He did not explain his attorney fee. He was nice to me. He offered, he said, oh, you don't know if your husband filed for complaint. I will be in a court. I can look up. Okay, you can look up, So when I made my choice, I'm like, okay, I will hire Mr. Schwab. I came to his office on December 13, 2024, and still I was thinking how the conversation will go, what he will say. The first thing that when I came to his office, I opened my mouth, he shut my mouth. He was talking for straight 1 hour. Mr. Schwab likes his voice, and it's okay. Some people like to talk, and it fits his profession. The meeting was 3 hours and 40 minutes. And Mr. Schwab was talking about subjects absolutely not related to my divorce case. For example, his family, himself, his former attorneys, his former clients from Ukrainian or Russian demographics, about Trump administration, about immigration law, about stuff absolutely not related. So I was thinking he's trying to make a good impression on me, break the ice, stuff like this, okay? And then he started to explain me a divorce law. So it was another hour. And then finally, he started to talk about contract, his fees, and explain his fees. So Mr. Schwab, the reason why I decided to hire him at the end of this meeting, because I respected his experience and he assured me that he will get the best settlement for me. He said, Irina, I have tons of divorce cases. I know what to do. I know that guys like your husband. I know what they want. Just trust me. And I trusted him naturally. Because any woman or man who receives such bad news will be upset, and he looking for someone who will guide them through this process. So we signed the contract at the end of the meeting. I paid a retainer fee for the future work to be done. And I was not aware about all these prior charges. Mr. Schwab said that he will send me monthly invoices. The first invoice was February 28th. It was a day when we had a conversation about our discovery going nowhere. I was upset, and I had a thought to terminate him as my attorney.
On February 28th,
Yes.
okay?
So after this conversation, Mr. Schwab sent me an invoice within 2 hours. First invoice. I will be honest. I look at this. I just opened this. I look at the final page. I'm like, okay. I didn't even go through line by line because I was upset about, first of all, hostile conversation for almost 2 hours. I was upset that my divorce going nowhere. I felt like I'm losing my case. I felt like my attorney don't understand what we need to do, because I was asking, let's subpoena the bank records, let's proceed with something. And he's like, no, let's do appraisals for premarital houses. Now we're going toward appraisals for premarital houses because Mr. Schwab covered this topic. It's another big chunk, 6,000 with something that he overcharged me for that. So Mr. Schwab told me, I offered you 2 appraisals for these houses. Okay. He explained me premarital properties and everything, but he's a licensed attorney. He should know better. I'm not an attorney. I'm a registered nurse. Why he told appraisals to do retro value 2014? We was boyfriend and girlfriend at that time, from 2014 to 2025. So it was 2 dates. That's why this data was not admitted on my mediation, because mediator said 2014, was you married that year? No, what year it was married? 2020. He said it should be 2020 to 2025. Maybe you get something. So it was ineffective. And Mr. Schwab, as an experienced attorney, should know that. He still imposes appraisal service of his choice, Mr. Grab from Northville, Michigan, which I suggested I can hire my appraisal service. He said, no, I'm not responsible for whoever you will hire. I said, I can hire a licensed appraisal. He convinced me. Mr. Schwab is very good in convincing. He convinced me that not this particular appraisal is very known to the court and judge. His data will be admitted without doubt, which was not. Also, I didn't know that Mr. Schwab will charge me for all the tones of conversation, emails, delivery of the checks, and everything in between me and mediator. I thought I will just pay for mediation service and that's it. So Mr. Schwab charged me $2,700 for his mediator work.
Well, you mean when you and your then estranged husband went to mediation, Mr. Schwab was there representing you, right?
No, it was Mr. Schwab was terminated by that time. But I got appraisal results, reports. I got appraisal reports from appraisal service and I.
So what are you complaining about him charging you with respect to mediation? I'm not understanding that.
So my complaint is that Mr. Schwab sent me an email and said that whole appraisal service will cost you $1,000. Don't be cheap, just pay it,
Okay.
and maybe you get something.
Okay,
At the end, it was $6,700, not $1,000
for the for the appraisers?
for total appraisal service. $3,570 for appraisal service, and the rest it was his emails with appraisal, call with appraisal, 3 hour and 40 minutes staying in my house and going to these houses. Which I don't understand how Mr. Schwab can justify, how you can charge legal fees for going to appraisal service. You know, these two people can operate independently. This is what they do for their living. He justifies this, oh, your husband could be hostile. If my husband would be hostile, these people will turn around and just leave. They will say, okay, we will just leave.
All right, so I want to get this straight. You're telling me that he told you it was going to be $1,000 for the appraisal
I
service?
have email.
Okay, that's fine. And then you're telling me the appraisal service costs $3,500?
Yes, because how he explained, he said, I didn't know that, but appraisal service will cost you so much money because they will do retroactive value 2014
Right,
and then 2025.
right.
So 2014 was not useful at all.
But the appraisal service actually charged you $3,500
Yes,
to appraise the 6 properties and give you a value of the property as of that date, as well as beginning from the time that you started cohabitating with
Yes.
Mr. Rizal.
yes.
Okay, go ahead.
So instead of 1,000, it was 3,570. And then when I received my second invoice after 2 days after I terminated Mr. Schwab, I got all this billing for his work, which I highlighted in my counter complaint. Was the rest of the money, it was for his.
And how much was that?
It was, actually, I don't have my papers, but it was,
I don't want you to guess.
around the 2,800 or
And
3,000.
was that billing that you're referring to, the 2,800, just for Mr. Schwab to go to the appraisals?
3 hours and 40 minutes just to go for appraisal service and 3 hours and 40 minutes for his coordinated work. So 6 hours and 80 minutes or whatever, how it adds
How
out,
much was he charging you again?
$375
Okay,
per hour.
Okay,
So that was a surprise fee for me when I received my second invoice 2 days after I terminated Mr. Schwab. So after that, I look at the rest and I've seen that I start to calculate where this all came from. And I already paid $10,000 for kids that just started, had no custody, no children, no motion files, no depositions, no meeting with a judge, no mediation. How I already paid 10,000 and I own 16 more. That's what made me to file for counter complaint. For case divorce that just started and financial discovery was not even finished.
so let me just ask you, how much did you pay Mr. Schwab altogether?
10,000.
And that did not include the appraisal fees, or did it?
Appraisal fees was separate, plus appraisal fees, $3,750.
So you paid him, and he paid the appraisal company, right?
Yes. I paid him personally 10,000 and I paid him to pay appraisal service.
$3,750.
Yes,
And you're saying for him to attend the appraisals, how much, and to coordinate that, how much did he charge you for that?
so calculate 3 hour and 40 minutes plus 3 hour and 40 minutes and times 375.
Okay, so you're at about, okay. Somewhere in the neighborhood about 2,800, because that's, okay, so that's 7 hours, 20 minutes at 375. Okay, what else would you like to tell me?
Mr. Schwab did numerous errors, as I said, with my filing my answer to complain. Then it was filed April 15 with the court. I went to the court. I went to the 3rd District Court in Detroit, and I talked to a supervisor and a manager, with everyone, and they personally checked for me. They said, we cannot.
Your Honor, I'll object 2 grounds. Any conversation, if she had any with somebody down at the court, is hearsay. Secondly, any testimony as to strategy, work, the file.
Yeah,
That is lack of foundation. She has no.
No, they just confirmed that was no pleadings filed prior to April 15. That's only what they could tell me. They said,
did you file, he filed the answer to complaint on April 15th though, right?
he's supposed to file this on January 10.
I know, you told me that, but he did file an answer to complaint at some point while he was still your lawyer, right?
And how he found out about this?
No, I wanted you to answer that.
He did.
Okay, so he did file it, that is a pleading, an answer to complaint, just so you know, but
But it was overdue by 123 days.
I know, but sometimes lawyers do that. They agree, listen, we'll just get to these when we can get to these. They're busy people, and he didn't harm your case by not filing that earlier because you never went into default.
But the opposing side could file a default judgment against.
I mean, I could get hit by a truck when I walk outside too. You know what I'm saying? Let's not talk about that.
Okay.
Okay, so what else do you want to tell me here?
So overcharging without my consent, appraisals, then discovery, my husband's financial statement, he never follow up, never forced opposing side to complete it properly. Interrogator is completely deficient. He charged me $2,400 for discovery, which led me to nowhere. So
When you say discovery, are you including the work on the appraisals or not?
I separate appraisals and discovery. Appraisals separate and
So
discovery
when you
separate.
refer to discovery, what are you talking about? His interrogatories to the other side?
In financial statement of my husband, that he didn't file any motion to compel them to file properly, the statement, so, and interrogatories, we never received interrogatories.
You never did.
While I had Mr. Schwab as my attorney, we never received the interrogatory.
From your husband's attorney.
Yes.
Correct. I got it.
I received them way after was my second attorney.
Right.
Follow up and, force them to do that. So lack of, like the Michigan court rule says, the attorney has to be diligent and jealously
You are a bright lady, you know that?
present.
You should maybe go to law school at some point, but sometimes we can read rules and not understand what's really going on in the practice. Do you understand what I'm saying? I mean, but I give you credit.
So I fired Mr. Schwab on April 14, 2025. The reason why I fired him, because we was arguing about interrogatories. I said, Mr. Schwab, file an amendment to interrogatories because they covering only houses. We need information from bank statements. He said, Irina, I will not do that because court will not allow me to do that. That's not true. So he didn't want to do that. He didn't want to look bad in front of the opposing side court or whatever. And I said,
You can only send 20 interrogatories.
he sent 13.
I know, but that doesn't mean you have to. Go ahead. Go ahead.
So I wanted him to do an addendum, few questions about his personal bank statements, CD accounts, where the big money was. He failed to do that. And I said, you know what, Mr. Schwab, we will put our relationship on hold. I'm emotional right now. You emotional. We was emotional to each other. And I said, let's put our relationship on hold. Give me a couple days to think and I get back to you. He said, okay, I have a mail confirming that. 2 hours after that, he sent it in email to opposing side about missing truck, something else, and charges me another $140. Okay, so that upset me, and I'm like, you know what? I'm done with that. And I sent him a letter that I terminated him. He ignored this letter completely. So next day, I was sending him another letter, and he responded finally on the second letter. And he finally stopped charging me because I couldn't tolerate any more charges.
Okay. I got it. Do you want to say anything else?
And the last thing that I want to say, that I felt obligated to file a complaint to Michigan Grievance Attorney Commission because I just felt like, people who going through hard time, like
They dismissed that, didn't they?
they didn't. No,
They didn't dismiss the committee.
no, they did not.
Your Honor,
I contacted the investigator, I have a letter from a senior representative of Michigan Grievance Attorney Commission, and I said, I have a trial on such and such day. Can I get some updates, maybe something? And he said, my investigation is still going due to complexity of the case and numbers of incidents.
Okay.
Your Honor, if this court believes it got a lot of paper, the attorney grievance has to have a foot. Again, they have done nothing. You. Because that's probably true. I mean, what she has filed is beyond comprehension. But that is going nowhere because a grievance, as you know, this is a dispute over fees. It's not sex. It is not the other thing, stealing property.
I understand. Okay. I get it. What else do you want to tell me?
Well, talking about sex, Mr. Schwab, on his first meeting, when we were signing the contract, made a remark, and I included this in counter complaint too, salacious comment. He told me that I know men as like your husband, and he will accuse you to having sex with me, which I looked at Mr. Schwab, and I don't want to say nothing about anything, but I said, I don't think so. This is what I told him. And he said, oh, you want to tell me that I'm too old for you? He repeated this comment a few times during our 3 other meetings.
Okay.
That's it, Your Honor.
All right. Why don't you have a seat
Your Honor, I would like to recross 3 questions.
Okay, go ahead.
Miss St. John, who was the woman sitting out at the reception desk when you were there on that first meeting?
On December 13, 2024,
No, the first.
was
thing you-
no woman sitting
Why
at the desk.
Sitting there?
No one was sitting there, Mr. Schwab. Good try.
Now,
Good.
you're complaining about the fee that the appraiser charged you? You paid that, didn't you?
My appraiser, it's your appraiser charged me, your reference
The
appraiser.
appraiser that we used, you paid it, didn't you?
I paid 3,570.
Didn't you?
I did objected this with you.
But you,
I objected this with you and you convinced me.
there were 7.
It will be in my cross-examination.
This thing, John, there were 7 homes appraised for appreciation purposes. That's less than $500 a house.
Was 5 houses.
Well, you own 6 plus your marital property, right?
4 premarital houses that my husband owns and a marital house, which I said, I don't want to appraise. I have emailed.
Can I ask you a question? Do you know what the combined total of the appraisal amounts was for all those houses? Do you have any idea?
I'll tell you, for premarital rentals was, I would say, 600.
Are you saying, I'm asking you, just what is the combined value of those appraised homes? Exclude the marital home?
600. Each would say in average 150.
Okay, good enough. Okay.
Plus,
So there was some money involved. You have to acknowledge that. I mean, he was trying to get you appraised. He was trying to get you 50% of the value between the time you started cohabitating with Mr. Rizal in 14 and up through the time that he was representing you. So there had to be some kind of money involved, is the point.
But Your Honor, I'm not objecting this money that I paid to appraisal service. I'm objecting all the rest of the money that Mr. Schwab charged to enrich himself. I never claimed that I want back $3,570 for appraisal service I paid. I never claimed this.
Okay.
this thing, John, I think you testified that you were surprised that I charged you for telephone calls.
Your Honor, I thought we will exchange now, and I see that it's just Mr. Schwab talking as always. I would like to object to that.
Okay. Well, he does.
He had his time to ask. Now
So wait a second. Wait. Let me tell you how we'll work it now. He gets to ask within the scope of your testimony, and then you can sit down. Then he's going to call himself, and then you're going to have the opportunity to cross-examine him, and then he can, so to speak, redirect himself. Okay? Go ahead.
You testified that you were surprised. You didn't know you'd be charged for telephone calls. You wouldn't be charged for emails. You
Yes,
wouldn't be charged for,
not excessive emails and phone calls.
okay, are you testifying that every time I did a piece of work, I had to get your permission to do it?
You don't have to have my permission, but your charges has to be reasonable, and they was unreasonable. The amount of work that you did and money I paid, unreasonable.
And you got the billing on February the 26th. Did you say this is unreasonable?
I did not object to this, but I am objecting your second invoice in addition with the first one.
Finally. The appraisal, in addition to trying to get you 50% of the appreciation during 14 through 25, we were also trying to get you 50% of the rental that he made, correct? Because you were going to testify that I went over there and cleaned up the houses, I schmoozed or I interacted with the tenants. I was his partner, correct?
There is no type of appreciation
Pardon?
from the marital time to now and cohabitated.
We're going to get all of it.
Did you get all of it?
I wasn't your attorney. You fired me. I have no further questions.
Okay, you can step down now, and you're going to testify, counsel?
Real brief, you know.
All right, you can clap here. And you told me this is gonna take 10 minutes, your testimony? All right.
At least not what I'm gonna testify to.
Raise your right hand. Solemnly swear affirming the penalties of perjury, the testimony you'll give in these proceedings, be the whole true self you got.
Thank you, Your Honor.
Okay, have a seat.
Well, my name is Paul Schwab. I'm a licensed attorney. I work by choice.
Is that 100% of your practice, pretty much? Is that, what percentage of your practice is divorce?
At the time I was representing this, St. John, probably 20-30% of my practice. Prior to that, more, but again, divorce work's a young man's work, and I'm not a young man. So I really stopped doing it. An unusual case, Miss St. John had really, a difficult life, immigrated from Ukraine. Her first husband, I believe, was tragically killed. They had a young child, and Mike Gazelle was, I believe, her husband's friend, and they married, or they lived together. Mike Gazelle, helped her. They then got married, and it's very tense. Miss St. John is a very strong woman and self-sufficient. She had problems with her daughter. Her daughter's a teenager going through a lot more than most teenagers are going through. I believe that Miss St. John was able to bring her family to this country on a legitimate immigration visa. I know that Miss St. John one afternoon appeared to my office and introduced me to her mother, introduced me to her brother. That's when I learned that they're living in an apartment building over on 12 Mile in Lasser. I know a Russian immigrant who lives there, Olga. And again, I even asked her parents or her mother, and there was some acknowledgement that, yeah, there's somebody there. So anyway, Miss St. John, we worked together. I have, an extensive divorce file. I would take her telephone calls. She would question, she would send me 4 or 5 pages of emails. I want you to do this. I want you to do that. I want you to do that. File more interrogatories. Do this, do that. And again, we're dealing with the Wayne County Family Court, and we got a 60-day deadline, and that judge is gonna set this for a mediation hearing, and I better be ready because we've got to have some theory. In addition, this theory of appreciation is really not that well codified in case law. But again, our strategy was we are going to go to mediation, and this is going to be a negotiated settlement. I had a lot of information on appreciation. He bought these homes as really a slum land. They were run down. One of them, I think, $60,000 to buy. Now they're worth $750,000. There's a lot of appreciation. And Michael Lazelle, a nice guy, but he's a smart businessman. He's not going to give away his money easily. He had his first attorney. Again, I know why. He told his attorney, I'm not giving him that information. Well, he fired that attorney, got the second attorney. Then I filed the interrogatories, and again, I listened to the earlier case when it's 20 questions, no subsections. Well, mine had 13 questions, but there were a lot of subsections, but the other attorney didn't object. And then I got this email, stop work. Well, You know, when a client says stop work, I go back there and say, oh, please give me another chance. I respectfully said, thank you. We had a nice friendship, a nice relationship. I've stopped work. I covered my backside. I wasn't gonna have her say, oh, well, why'd you stop work? Because you told me to. And again, I had attached it to some of the myriad pleading. And again, I had email after email after email and talking to her. And again, yes, this first meeting when you are representing a young woman whose whole world is collapsing, they're looking for comfort, they're looking for strength, they're looking for support. And that's what I tried to give her. And I tried to prepare her. Her husband already lied to her about filing the complaint just to stick it to her and twist the knife. And that upset her to no end. Then we got a copy of the complaint. And as soon as I gave it to Miss St. John, I emailed it to her immediately. She was served. So again, husband's playing games with her. Husband was playing games with her throughout this entire thing. Even playing the daughter tragically. The daughter, you know, really almost treated him like, father figure. Again, nothing untoward, but very, very strong emotional attachment. I felt badly for this young daughter, 13, 14, also questioning, her sexuality, her sexual identity, depression. It's just a very, very dangerous. And I tried to comfort Irene on that, tried to support her. But again, I wanted to prepare her that, look, your husband isn't done attacking. And one of these husbands always accuse you of having sex with your attorney. I said, look at me. This is on your side. And I told her, my wife works here. They don't disclose to clients my wife is sitting up there at the desk if I have some ulterior motive. And again, giving her records and the phone records, I don't know, but I try to keep her informed. Again, a narrative building, when you look at it, I didn't make this up 2 days ago. We keep contemporaneous records. I was trained as an insurance defense attorney. I used to keep insurance companies happy. And I keep copious records. No objections, no nothing, until I decide you want me money, I'm going to file a lawsuit. And then she files these complaints. And again,
I'm sorry, how much do you think she owes you right now again?
$1,312.
So there's a bit of a disparity. Yeah, 1627.70. But she told me, right? I think she told me that she paid you.
She paid me $10,000. She gave me two retainers. When the first billing was sent to her.
So actually your total bill for her case was $11,627.70. Am I reading you right?
That's correct. Because the first billing was $6,176. I applied her $5,000 retainer. That left an unpaid balance. I carried that forward. After the February 26th, 2025 billing, she gave me another $5,000 retainer. She was happy with my work. She wanted me as her attorney. So she gave me that money, and I applied it, as I am required to do, to the final billing. And when I applied it, I listed, if you look at the final billing, it says so much for attorney fees. Previous balance, I want to say $176. I apply the $5,000 unearned second retainer, and that left the balance. Every penny is accounted for. Every,
What do you, let me ask you this. What did you think his net worth was? His. Had you gotten that far?
Only the Groseel house. The Groseel house is probably worth $600,000-$700,000. They're not on a canal, but it's a nice house. It was probably built I would say in the mid-60s, you know, but it's nice. And he restored it because I was there one day to see the house. I wanted to see what we were dealing with as marital. Because she's gonna get half of that house.
Right.
They bought it together and I think she even put most of the money down. So she was gonna get it. Well, I wanted to be able to tell the other attorney, I was there. And it would be a house that quite honestly, my wife and I would buy. It's on Roselle and that property is worth a lot. So I would say that house is probably worth 600,000, 700,000. And he's got all of this rental property.
Plus, what else did he have? Do you have any idea?
As I believe.
No, but I mean, did you get far enough to determine whether or not he had money in
He's got some money in
stock markets or retirement funds?
because under divorce law, they are supposed to, under the new thing, there's a, I'll call it a FIFA form, financial information disclosure form. And you're supposed to list everything. Well, the attorney gave it to him, and he just wrote it out in handwriting and sent it back. And I objected to that. I told this Mark Gilbert, I said, Mark, there's a lot of deficiencies and correct this, correct that, correct that. Because also the judges in the Wayne County Family Court expect two intelligent attorneys to be able to work out discovery questions. And I did. And I said, Mark, give us this information. Give us that information. She says, subpoena. A layperson doesn't understand. You send a subpoena to America, it's 3 or 4 months and they charge you $1 a page. Whereas I can get the same information from the attorney. So the attorney and I were working. Also, the reason the answer wasn't filed that far, because the attorney said, oh, lie low, let's talk, let's see if we can.
Right, I figured.
Yeah, yeah.
All right.
Yeah, so that is it. And like I say, again, I still respect Irina. She tragically does not understand what went on in a legal point of view. She expects us to be, like too late. It doesn't work that way in divorce law.
Do you have questions?
I do have a few questions.
Okay.
First question, Your Honor, you asked Mr. Schwab, how do you think the marital house in Brazil cost? And he says, I think it's $600-700. There is no $1,000. There is nothing to think. Appraisal was done. I paid for the appraisal, and it stated it's worth $430,000. It's not on a quarter, and I didn't want to do appraisal for the marital house, and I insisted with Mr. Schwab in my emails that I don't want to do appraisal on a marital house because I will get 50% anyway. It's a marital property. We put money together, 50-50. We pay mortgage together.
Okay.
So.
Okay, but this is the time to ask them questions.
Yeah, so Mr. Schwab, did the appraisal service appraised my marital house in $430,000?
Yes, can I ask you? You wanted that house and you were willing to waive all of your interest in the rental properties, correct? You wanted to continue living in Grosse, correct?
I wanted two options, or stay in a house with my daughter or sell it and split it 50-50. That's why I said appraisal not necessary, because if it will be sold, it will be split by law 50-50.
And what were you
My
gonna
next
split? What were
my
you
next
gonna split?
question-
What value were you gonna split if you didn't have a license to appraise it?
The mediator used Zillow appraisal value. Opposing side used Zillow appraisal value as
Okay, why don't we do this? Why don't you stick to the questions and you're gonna just give the answers. Go ahead.
My next question is, did you just stated that you've been in my house before?
Yes,
Can you please tell me when you've been in my house before? State the date, please.
there was no snow on the ground, so I would have to say, you hired me in December. I'll be there probably end of January.
What you was doing in my house?
I was with you. Your husband wasn't there and you walked me around, you showed me the lower level. Yes,
Your Honor, I have no recollection of this event happening. Mr. Schwab first time entered in my house at the day of the appraisal.
Okay, so you gotta tell me
Oh.
that on your other,
Miss St.
I don't
John,
know how to address that. It's,
well, you dispute that.
Miss St. John, I wasn't in your house on the day of the appraisal. I stood on the driveway. Your husband, maybe the appraiser and the appraiser's assistant, your husband, but they were already out of the house when I arrived because I got lost.
I object in this, Your Honor, because that's absolutely not true. Mr. Schwab first time came in my house on a day of the appraisal service. He been physically inside
Okay,
my
you're
house.
gonna have to tell me that when you're testifying. Right now, you're just asking questions, though.
Okay.
Does it really matter whether he was in there before the appraisal, after the
It
appraisal?
doesn't matter, but when somebody says something that never happened, you know, I have to
Okay,
object
okay,
to
fair enough,
something.
fair enough.
So, also my next question is that, so it was appraisal of the marital house, the premarital for rental properties, that did you told appraisal service to appraise premarital for rental houses, on retro value 2014?
Yes,
And did you know that at that time legally was not married?
yes,
And did you know or anticipated that this value probably will be not accepted by court or mediator?
there's no way to predict that. This was negotiation.
Okay, did you order appraisal value at the marital year of 2020?
I believe that's incorporated in the appraisal report, but you have to understand that you are not entitled to appreciation from 2014 to the day of the marriage because that was your husband's separate property. We were
But
going
you still
under.
ordered.
Wait, just let him finish.
We were going under, and I explained this to you, a business theory that while you and your husband were living together, you were business partners. You were working together to enhance and make a profit on that. And we were really settling or putting a claim in that you were going to get 50% of the appreciation as your husband's business partner. That is the theory. It's a unique theory, but it was for the purposes of mediation only. I didn't know what the judge in the family court was going to do.
My next question is, as a licensed attorney with extended experience, do you think it would be more appropriate to order appraisal date of 2020, year of the marriage?
No, because you have no claim to that property. That is your husband's separate property. That those rental homes are non-marital. Unless your name were on those rental homes, you cannot give any money for them, even though you're married.
Mr. Schwab, my next question is, did you receive a request for production from me, but through the Michigan filing?
In this case,
Yes.
yes,
Did I ask you to provide any document, note, letter, email, report, anything that proves my authorization for any search-related work or legal representation prior to December 13, 2024?
I don't remember, but I know that the requests for production were rambling, non-specific. I couldn't even understand, and I objected to those requests, and you never asked the court to rule on whether or not my objections were valid. And
You
so I
responded.
answered those.
Response to request one is not possible. My next question is, if after our conversation on the phone prior to December 13, if I never show up in your office on December 13 to sign that contract, how would you claim all the charges? How would you present them to the court? How would you sue me for that?
First of all, you have to understand, to have a contract, you don't need a piece of paper. You can have a request, or you request, Mr. Schwab, I want you to do something, or I offer to do something.
Can you present this
Wait,
request?
let him finish, let me finish, let me finish.
Okay, you call me and I offer to go down to the court to look at it. And you accept that offer. That is a contract. Then I can assure you that with that type of an issue, I would have said, I'm gonna have to charge you for that.
Did you disclose your attorney fee prior to December 13?
More than
Did you
likely,
explain them to me?
more than likely in the first telephone call, I
But you
would have
have
said,
Wait a minute, man, wait, man, come on, you got him?
I'm talking about the practice of law. You called me, Mr. Schwab, I want you to represent me. I'm looking for a divorce attorney. The first thing is, can you afford me? And I would have said, I would like to represent you, but my hourly rate is $75 an hour. I charge, it's computerized. I charge by tenths of an hour. You have to pay me for this, this, and this. Sometimes there are no charges. Then we go forward. But it's not fair to a client to have them come in, waste their time, and then break the news to them. It's $375 an hour. I might as well say it's 3.7 million. There are some people who cannot. Now, you said, I'm an oncology nurse. I work for Carmanos. Money, yeah, I can handle it. Of course, we discussed fees.
I will object this. We did not discuss fees on a first conversation.
So you're gonna have to come back up and tell me that when you testify again, okay?
My next question is, you produced two orders, status quo and stipulated mutual restraining order when you filed the answer to complaint.
Yes,
Did you file them?
no, I did not.
But did you charge them? Did you charge me for them for production of this
I
orders?
probably did. I did the work.
Okay,
But the reason they weren't filed was because I talked to your husband's attorney and we had an agreement. There was not going to be any destruction of assets. That's why you get the injunction. And secondly, you were living together. You were sharing your bills. You were sharing utilities. You weren't going to be out on the street. So to save you money, I didn't file either one of those. Plus, once the attorney's involved, we have to have a court hearing, and that's going to charge you another $1,000. It wasn't necessary, and you were not damaged by it.
so according to your answer, you didn't file answer for my answer to complaint. These two stipulated order, you charged me for them, but didn't file them to save me money.
Yes, I did the work, but I didn't file them.
Why did you do the work if you and the other lawyer had an agreement?
Because at the time, I didn't know if the husband actually filed the complaint. Because I went down there and there's no record of it, nothing. Miss St. John was very, very anxious. So I did and then the second time, once I got the complaint, the other attorney had no injunction, which is not at all unusual. So I prepared the property injunction. You cannot let, insurance policies lapse. You can't sell property. You can't conceal property. You can't damage property. That's crap. The status quo says, Mr. O'Dell, you have to contribute keeping the utilities on. You have to contribute to the house. Those are the two. Those are standard. That would be malpractice not to, unless you have the other attorney say, we're not going to have that problem. And we never did. They continued to live together. So yes, I was prepared.
Okay,
Mr. Schwab, did I provided you with a copy of, did I provide you with original of complaint and summons on December 13, 2024, when I came to your office? Because with certified mail, did I provide you with original?
I believe you did, but by that time I had a copy also. But I believe you came to the office, it was, I was served, yes. Again, I think they served you by mail, but I'm not sure. But yes, you came with the complaint and the summons, but I had that already from, my meeting at the Wayne County.
I was sorted the same day. I was sorted the same day when I came to you, actually.
Yes, you were, I didn't serve you.
Mr. Schwab, after you received the financial statement from my husband and you seen that it was grossly deficient, a lot of information was missing, what was your follow-up on that?
I spent his attorney, well, first of all, you and I spent considerable amount of time. And I believe I'm paging through my divorce file. I believe you gave me some notes as to what was deficient. Then I have an email here to the attorney that said, Mark.
I hate to do this, but it's 1:15.
Yeah.
Let's go I'm gonna go have some lunch. And you guys can have lunch. Can we all be back here at 2:00?
Okay.
Okay?
Yeah.
See everybody back here then. Thank you.